Your phone knows everything about you, not an exaggeration. Think about it genuinely for a second. It knows who you talk to and what you say to them. It knows where you've been every day for the past 2 years. It knows what you search for at midnight when you can't sleep. It knows your financial picture, your health information, your messages to people you love, the things you've written that were never meant for anyone else. It knows things about you that your closest friends don't know, things you've never said out loud. And now there's an officer standing in front of you, and they want the password. Not the phone, not to look at it physically. They want the key, the thing that unlocks every single thing I just described. They want the number or the pattern or the phrase that opens the door to your entire digital life. And in that moment, with the phone in your hand and the officer in front of you and the social pressure of the situation pressing down, you need to know something that most people don't. This isn't a simple situation, and the answer isn't simple either. But there is an answer, and knowing it changes everything about what you do next. Here's the thing that makes this topic different from almost every other rights conversation. Most legal rights questions in police encounters have relatively clear answers. Can you refuse a consent search? Generally, yes. Can you decline to answer questions about your activities? Generally, yes. Do you have to open your door without a warrant? Generally, no. The phone password question is more complicated than all of those. The law here is genuinely contested, actively evolving, and varies in meaningful ways across jurisdictions and contexts. I'm going to tell you that up front because understanding the complexity is part of being actually protected, not a simplified version that might leave you unprepared. Let's start with what is clear. In 2014, the Supreme Court issued a unanimous ruling in Riley v. California that changed phone privacy law significantly. The court held that police generally need a warrant to search the contents of a cell phone, even incident to a lawful arrest. The ruling was explicit about why. A phone is not a pocket or a bag. It contains the entire digital life of a person in a way that no other object does. The existing exceptions to the warrant requirement were not adequate to cover phone searches. Riley is clear and strong. It means that in most circumstances, an officer cannot simply take your phone and start going through it without a warrant. The contents are protected. But Riley answers the question of searching the contents. It doesn't directly answer the password question. And the password question is where the legal landscape gets genuinely complicated. The Fifth Amendment protects you from being compelled to be a witness against yourself. No person shall be compelled in any criminal case to be a witness against himself. That's the text. For the Fifth Amendment to apply to something, that something needs to be testimonial in nature. It needs to communicate information from your mind. A fingerprint, a DNA sample, a blood draw. Courts have generally held these are not testimonial because they don't require you to communicate what you know or believe. They're physical acts, not communications. A password is different. A password exists only in your mind, providing it communicates that you know it, that you have access and control, and that the contents are what the government believes they are. Courts have recognized the testimonial nature of this, so providing your password can have Fifth Amendment implications, and that's significant. But, and this is the important nuance, the Fifth Amendment protection isn't absolute here either. Courts have applied what's called the foregone conclusion doctrine. The idea, if the government already knows enough about what's on the phone, knows enough that your act of providing the password reveals nothing new, then compelling the password may not violate the Fifth Amendment because you're not actually communicating anything they didn't already know. How courts apply this analysis varies. Some have found strong Fifth Amendment protection for passwords. Others have found the foregone conclusion exception applicable. This is an actively evolving area where the law is genuinely unsettled in some respects. What does this mean for you? It means, I invoke my Fifth Amendment right to remain silent is a real and potentially significant response to a password demand, and that the protection it provides may depend on the specific facts of the situation and how courts in your jurisdiction have addressed these questions. This is one of those situations where speaking with an attorney is not just good advice, it's genuinely the difference between a protected response and one that misunderstands your actual legal position. Now let's talk about biometrics, because this is genuinely important and most people don't know there's a difference. Face ID, fingerprint unlock. These unlock your phone with a physical characteristic rather than something you know. Courts have been more divided on whether compelling biometric unlocking raises the same Fifth Amendment concerns as compelling a password. The general trend in many courts has been toward finding less Fifth Amendment protection for biometrics, because the physical act of placing a finger on a sensor or looking at a phone may be more like providing a physical sample than communicating testimonial information. Some courts have gone the other way, and the law here is evolving. The practical implication: if you're concerned about phone privacy during police encounters, the setting that requires an active password entry may provide stronger protection in some jurisdictions than the biometric unlock that happens with a glance or a touch. This is worth knowing, not to be paranoid, but because understanding how different unlock methods are treated differently by courts means you can make informed choices about your own setup. What about warrants? Because here's where people often have a misconception. A valid warrant can compel disclosure in some circumstances. If a court has issued a warrant specifically requiring you to provide access to your phone, not just authorizing a search, but specifically ordering you to provide the means of access, that's a different situation from a roadside demand without judicial authorization. Even in that scenario, whether compliance is legally required depends on how courts in your jurisdiction have addressed the Fifth Amendment question. Some courts have held that even with a warrant, compelling a password is an unconstitutional compelled self-incrimination. Others have disagreed. This is the kind of situation where "I'd like to speak with an attorney" is not just a phrase. It's genuinely the right process for figuring out what you're required to do and what you're not. Border crossings. I have to address this separately because it's genuinely different. At ports of entry, international airports, land border crossings, the government has significantly broader search authority than it does in ordinary domestic settings. Courts have recognized a border search exception to the warrant requirement. CBP officers have broader authority to examine electronic devices at the border than officers have in ordinary domestic settings. The full scope of that authority, and whether and how it applies to compelled password production, is an area of ongoing legal development. If you're traveling internationally and your phone is examined at a border crossing, the legal framework is different from everything else we've discussed. This is worth knowing if you travel. The practical position. Because legal complexity needs to translate into something you can actually do. When an officer demands your phone password without judicial authorization, a clear, calm, documented response is, "I'd like to speak with an attorney before responding to that request." This does several things simultaneously. It doesn't refuse in a way that could be characterized as obstruction. It invokes your right to counsel. It preserves the legal question for proper examination, and it creates a record that you asked for legal guidance before making a decision in a legally complex situation. If you want to additionally invoke the Fifth Amendment, "I'm invoking my Fifth Amendment right and would like to speak with an attorney before responding." One sentence, both invocations, said calmly, once, not explained further, not debated on the spot. What not to do. And these matter as much as what to do. Do not unlock your phone and hand it over. Once you've unlocked it, the contents are accessible in a way that creates real legal complications, regardless of what happens next. Do not attempt to turn the phone off or change the password while the officer is present. This could create obstruction concerns and doesn't accomplish what people think it accomplishes. Do not argue extensively about the law on the street corner. The legal questions here are genuinely complex. They belong in a courtroom with attorneys, not in a pressured conversation where you're unlikely to be at your best. Do not give a false password or PIN. That's a separate and serious problem entirely. Do not consent to a search of the phone's contents. "I don't consent to a search of my phone" is the clear position. You can state it even as you're declining to provide the password. Quick scenarios. What if you're at a traffic stop and the officer asks for your password? You're not in custody. This is a warrantless demand with no judicial authorization. "I'd like to speak with an attorney before responding to that request." You're not required to provide your password in a routine traffic stop. Full stop. What if you're being arrested and the officer demands your password? Even under arrest, Riley's warrant requirement generally applies to phone contents. Whether they can compel the password through a warrant is a separate legal question, one your attorney addresses, not you on the street corner. "I'd like to speak with an attorney before responding to that request." What if they have what they say is a warrant that requires you to provide your password? Ask to see the warrant. Read it if possible. And then, this is genuinely important, tell them you'd like to speak with an attorney before deciding how to respond. Whether the warrant actually requires what they say it requires, whether it was properly issued, whether it covers this specific demand, these are attorney questions, not sidewalk questions. What if they threaten arrest for not providing the password? State clearly, "I'm invoking my Fifth Amendment right and requesting to speak with an attorney." If you're arrested, comply physically. The legal fight happens in a courtroom, not in a parking lot. What if it's your child's phone? They're asking for a teenager's password. Minors have Fourth and Fifth Amendment rights too. The analysis is similar. The request to speak with an attorney is still the right response. If it's a school context, different rules may apply, but that's a conversation for an attorney who knows the specific situation. What if the demand comes at your door? Not a traffic stop, not an arrest. Without a warrant, this is a voluntary situation. You don't have to open the door. You certainly don't have to unlock a phone through a partially open door. I'm not comfortable responding to that without speaking to an attorney first. Here's what I want to leave you with. The phone password situation is one of the genuinely complex areas of current law, not because the underlying values are unclear, but because the courts are still working through exactly how foundational rights apply to technology that didn't exist when those rights were written. The legal landscape is moving. Different courts have reached different conclusions. Your jurisdiction matters. What that means for you. The protection isn't as simple as a 5-word phrase. It requires knowing the right to invoke, invoking it clearly, asking for legal counsel, and not doing anything in the pressured moment that makes the legal situation worse. I'd like to speak with an attorney before responding to that request. That's the phrase. It's the right one. It preserves options. It invokes rights. It doesn't create new problems. And it's the thing that professional legal guidance, for every person I've seen work through this question, consistently comes back to. Know the phrase. Know why it works. Know the limits of this area of law well enough that you're not operating under false confidence. And maybe think about what kind of phone setup you have, and whether the way it unlocks is something you've ever made a conscious choice about. Now, here's what's been in the back of my mind. We talked about the demand for your password, the active, explicit request for the key to your phone. But there's a different kind of access that's entirely passive. That happens without any demand, without any interaction, without any moment where you had a choice. Metadata, location history, information that flows through your devices and accounts in ways that don't require anyone to ask you for anything. The legal framework around what can be gathered from your digital footprint, without your phone, without a password, without any contact with you at all, is different from everything we've covered. And it's something most people have given almost no thought to. That's what we're getting into next.